Hey there, good to have you here. Welcome back. As soon as the results were declared, I started receiving emails, messages, and YouTube comments, and it felt really good. The birds were returning to the nest. So welcome home, welcome back. First thing first, congratulations on qualifying the written test. Good job. But you know what is the great thing that has happened? Regardless of the result, you have gone through the Patent Act and the videos, not once, twice, but multiple times. This puts you in such a beautiful position. Given a patent-related situation, I am confident that you can think through the solutions based on the options which are available in the Patent Act. You may be required to refer to the Patent Act, but then flipping through the pages to go through that particular section or that particular rule to provide solution to the situation that we were talking about would be much easier, comparatively easier than what you could have done earlier. So isn't that a great thing to have? You have the knowledge, you have the experience of the act. Now, to act as a patent agent, all you need is a certification from the patent office. Now, for that to happen, you need to convince the patent office that you indeed have the knowledge. Now, with regards to the interview round or the Viva, in my humble opinion, the patent office is taking this platform as an opportunity to get to know you more, to evaluate your personality, and as they say, put face to the text that they have already evaluated while evaluating your paper 1 and paper 2 responses. Now the burning question is, how do we approach the interview? How do we crack the interview? Or how do we convince the patent office that we indeed have the knowledge to act as the patent agent? Now for that, my first and foremost suggestion, not only specific to this interaction, but any interaction that you may have, is to be humble and treat everyone and every question with respect. Be calm and composed and polite while delivering your response. Remember, language is just a tool. It's the substance, the material, the knowledge that you deliver through your message or your response matters. It's the most essential part of your response. So do justice to your knowledge. The knowledge that you have already acquired by flipping through the pages, by watching the videos so many times. Do justice to that and put maximum efficiency in delivering that knowledge to the question that they have asked to meet the objective of the question. Moving to the logistics part of the interviews. As it has been happening for many years now, the patent office creates multiple interview panels that takes interviews in parallel. Each such interview may last from 5 to 10 to 25 to 30 minutes based on how engaging or interesting interaction you are having with the board and the board with you. And it is imperative and obvious that each interview will take its own course based on your education background, your technological domain, or your profile as of now. And like any other interview, various questions will be asked to assess your personality, your educational background, your technological knowledge, and your knowledge about the Patent Act, and your philosophy about various related topics. Could be technology, could be patents. So an interview can be divided into multiple sections based on the objective of the questions. So I've tried to divide the interview in multiple sections, and we will discuss potential questions for each of these sections as the video progresses, starting with the first one. So the first portion of the interview could be considered as a general round or introduction round, where a few questions could be asked based on your journey so far, your story so far. What have you been doing in life? What is your education background? If you're working somewhere, what is the job profile? What are you working on? What are the products that you know of? What are the services that you provide? And related to that, let's say if you are in a core technology company, a few questions about, let's say, the technology itself, a few questions about the innovations in the technology. If you're working in a non-core company, the questions could be, why are you not working in a core company? Because you are an engineer, you are a technologist, so why are you not working in a core company? You have to provide your own responses to it. Remember, nothing is wrong, nothing is right. It's what your story is, right? So you provide your responses to that. And because you are appearing for a patent agent qualification, they may ask you, why would you want to become a patent agent? How does it add value to what you are exactly doing right now? or how would it add value to the society? What is your vision for the society? Could be a philosophical question. How would you want to help the innovators in getting their patents? Or how would you want to help patent office in, let's say, providing efficient services to the innovations? All philosophical, but then it's the whys around it. Why would you want to join the ecosystem in the capacity of patent agent, and what would you want to do henceforth? Talking about technology, a few questions could be asked about technology itself, and they may come up with, let's say, a rough idea there and then in the technology, and may ask you to, let's say, apply section 2 to understand the inventions, new inventions, obviousness, and may ask you to apply section 3, the multiple parts of it, to evaluate the patent eligibility of the idea in the domain that they spoke of. So what they are trying to evaluate is, within your technological domain, can you apply your technology acumen plus the knowledge of Patent Act to come to a conclusion whether a particular idea or the invention in that particular technology domain is patent eligible or not. Basically, this portion is driven by your responses, how interesting responses you're providing, or what kind of stand you are taking with respect to, let's say, section 3K, section 3D, section 3M, or any other relevant section to your technology. The person on the other side may ask further questions related to the responses that you provide. So it's all driven by you. So be smart in answering, be open in answering, and be yourself. Because you know the technology, because you know the Patent Act, answer accordingly. Remember, there is nothing wrong, nothing right. It's your stand, it's your thought process, it's your perception, isn't it? Now, with regards to technology, we are living through an exciting times where so much innovation is happening in the field of artificial intelligence. We have generative AIs, ChatGPT, we have blockchain, we have cryptocurrencies, we have different fintech based solutions coming out. So are these patent eligible? Section 3K being the biggest hurdle in all this. So many courts have come up with their own observation with regards to computer related inventions, and how patent office should look at these inventions from the point of view of technical solutions that they are providing to a technical problem, and how they are enhancing the technology as such, how they are advancing the technology as such, right? So you can use all these pointers to help yourself to navigate through the questions, the section 3Ks, and the patent eligibility questions with regards to the new technologies that are coming forward. See, it's very challenging to come up with an exhaustive list of questions that they can ask. But then, based on the domain that you are coming from, you can maybe anticipate, predict that, these kind of questions can come. And if they're asking technological questions, they are definitely going to tie it up with some Patent Act related questions. It could be too early, but then they can ask you maybe to, give them a rough skeleton claim also for any idea or technology that they are discussing. Don't worry about the novelty, obviousness, other aspects of the claims right now, but the structure, the transition, and the preamble that we spoke of during the preparation as well, right? So have some hang of it, and don't get surprised if they were to ask such questions. Be calm, be composed, and provide solution, provide the claim that they are asking you for. So with this, the interview might start moving towards assessing your IP knowledge. So what kind of questions can we expect there? In this portion of the interview, majority of the questions will be directed towards testing your IP knowledge. Now, they could be straightforward questions or could be scenario-based questions. Now, straightforward questions could be why, what nots about patent, different type of IPRs, difference between patent versus copyright, patent versus trademark, patent versus trade secret, copyright versus trademark, why to use, when to use, right? For example, functionality to be claimed by patents, expression by copyright, trademark is, of course, trademark, trade secret is something that you don't want to make available to public. So you, again, not an exhaustive list, but then some general knowledge about different type of IPRs and how they differ from each other would be handy. They're not testing you to be an expert, but then you need to know the difference. A patent agent need to know what goes as copyright, what goes as trademark, and what goes as patent. For scenario-based questions, think of the life cycle of an idea, patent application, or a patent, granted patent. A situation or a scenario can be pulled out from any stage of this life cycle and can be presented to you. The idea is to provide a solution for this scenario, this situation, using the options available in the Patent Act as per the sections and the rules. So what kind of scenarios are we talking about? So from the life cycle point of view, the first thing is, what is an invention? How do you define or evaluate the patentability of it? A scenario can be given to you. Who is an inventor? Who can be termed as an inventor? So we have section 6. If not that, we know that anybody who contributes to a claim can be termed as an inventor. Now, how do you file a patent application? What forms do you use to file a patent application? Moving to the type of the application, what is the difference between provisional application and a regular application? Under what circumstances do you file a provisional application versus a regular application? What are the timelines of provisional versus regular? Can you convert a regular to a provisional application? Can you combine multiple provisional to come up with a regular application? You know, the questions are endless. It's the combination of all the sections that we have, you can have a question. But moving on with the train of thoughts, how do you file an application? Do you have to first file the application in India? If you don't want to file application in India, what are the provisions that are available to us? Basically, a client can come to you saying that I would want to file in the US. What do I do? So what sections helps us to do that? Similarly, let's say once you have filed an application, what goes in the specification, section 10? What kind of details are we expected to provide there? What kind of claims needs to be there? What is the requirement from the claims? If you happen to be from the pharma domain, a question can be asked regarding biodiversity or the information regarding biological material. How do you provide such information and when do you provide such information? Isn't it? Moving on, we can talk about, or maybe they can ask questions regarding what activities can be considered as anticipatory activities or what activities are exempted from such anticipations. You know the sections, right? Flip through the pages again or watch the videos. Similarly, what are the infringing activities or what activities are not considered as infringing activities? You know the sections, I know that. Moving on, let's say pre-grant, post-grant, and any other revocation proceedings that we can take. What are the sections and what are the grounds that can be used? Don't worry, you can just sprinkle few grounds that comes to your mind and help you navigate through the questions. There could be few questions regarding compulsory licensing. If they ask you, what are the grounds? What are the public requirements that we talk about? Isn't it? And who can file for a compulsory licensing? Do you need to approach the patentee first before opting for a compulsory licensing or before approaching the controller for compulsory licensing? So, you know, the list is endless. The entire act is there in front of you. And trust me, you have read through the act. You know every bit about it, at least to talk to them, but to sprinkle your knowledge, to navigate your way through the scenario that they might provide you. So don't sweat over it. You have the knowledge. You have qualified the paper too. Now, before I forget, see, there could be few specific questions also, special questions as I say them. See, we had COVID-related issues recently. So how do you handle such situations from patent's point of view? Remember, there were a lot of talks regarding compulsory licensing. There were a lot of talks regarding waiver of IPR rights so that the patented drugs or patented inventions were freely available for the governments to treat their citizens, isn't it? Questions around it. And then there could be questions around startups. Who is a startup and what is a startup and why the government needs to help them or what kind of help is provided to them. So government is incentivizing them. Could be a philosophical question. Do we really need to incentivize it? What do we get in return? And you know, endless questions. Any more questions will branch out based on what kind of response you provide to them. Anything else? I think we can have a bit of knowledge about, let's say, standard essential patents also. because a lot of cases happen around it. And favorite questions around section 3K, why software patents? So remember, technical solution to technical problem is what one need to see. One doesn't need to see the form, shape, size of an invention. If the invention is providing technical solution to a technical problem, it should be considered as patent eligible subject matter. Now, whether this is patentable or not will be defined based on what kind of prior art is available around us. Talking of prior art, they can ask what is considered as prior art, section 13, and what may not be considered as prior art, the anticipation sections, remember? Moving on, specific questions regarding the standard forms could be asked. Let's say, what are the forms to file an application? At least these many forms you need to remember. And then there are a few special forms which are required to, let's say, oppose anything that's happening at the patent office, or the requirement of form 30, the requirement of form 28. I will not tell what these forms are for. Please flip through the pages of the act. And form 27, what is the use of form 27? Because we spoke about expedited examination, what are the forms required for expedited examination? What are the forms required for early publication? I hope you understand that I may not be able to provide you with an exhaustive set of questions, but then what all do you need to know? What all information do you need to have at the top of your mind so that you can engage in a discussion with them and can navigate through the interview? By now, you have provided the panel with enough information about yourself, enough information about what kind of knowledge you possess on technology, on IP, and in general. But they may want to know whether you are really interested in the field or not. And how do they know? The easiest parameter to check if you are really interested in the domain is to check if you are following the latest updates in the industry or not. Now, what are these updates that we are talking about? The updates could be with regards to the amendments to the rules or sections of the Patent Act. What was the purpose of such amendments? And what are these amendments? Are there any new forms that have been defined? Are there any changes to the timelines or process? And why these timelines or process were changed? What was the objective behind it? A lot is happening between Delhi High Court and Patent Office with regards to how certain inventions should be looked into by the Patent Office. So what are those conclusions? What are those remarks? Are you aware of those? Can we say that everything is settled, or are we still looking for more case laws to decide on how computer-related inventions need to be treated by the Patent Office? There are so many initiatives taken by the government for encouraging IPR. There is a Startup India program. You may want to read through it to understand how patent gets plugged into it or IPR gets plugged into it. There is this facilitator program. You may want to know more about it, how the experts provide their services to what kind of applicants. Then there are few programs which sponsors patent-related fees. So who all these guys are, who is eligible for such programs. Then there are few incentives provided for innovations in few particular technological domains. Then, of course, expedited examination, expedited processes at the Patent Office, eligibility, timelines. You may want to read a lot about it. On the similar lines, there could be many more aspects which would be good to know, because questions can be asked from any which way. As I said, it's completely driven by how you respond, and it's completely driven by what kind of discussions or interactions you are having with the panel. On the similar lines, you may want to dig more to understand if there are more IPR related schemes or IPR related developments that have happened in the country to either incentivize the applicants or to maybe make the process more efficient at the Patent Office. There could be many more, and the questions are limitless. You would know that. So at this stage, I'm hoping that either your 5th or 25th or 30th minute with the panel gets over. So I hope you understand the purpose of this video, the purpose of this narration and purpose of this discussion that we had was only to give you a hint, a glimpse of what to expect in an interview. What kind of questions, what type of scenarios can be created in the interview. Because It is next to impossible to create an exhaustive list of questions that can be asked by the panel. Because as we discussed already, the interview is actually driven by you, your profile. The questions are literally branched out based on your responses, based on what kind of interaction you are able to have with the panel. So it can go on and on and on. There is no limit to it. But one thing that I'm really, really certain of is that I believe in you. You have the necessary knowledge. Come on, you have already qualified the written test. So you know your act. You have gone through the act multiple times. You have seen my videos numerous number of times. So you have the knowledge. All you need to do is be calm and confidently provide your response, your stand, your thought, your perceptions. Don't think of right and wrong when the question is not absolute. Just provide your understanding. That is good enough. With this, I wish you the very best for the Viva, and I hope that I will get to work with a few of you as we move forward. If you have any more questions, please put them in comments, and I will try my level best to provide some response to them. Take care. Goodbye.